Hello, everyone, and welcome to Area of Study 2 of Unit 3, our first key knowledge dot point. I would suggest that today will be one of our quicker videos. It's a very brief dot point, so we'll fly through it pretty quickly. As always, quick quote. When I hear somebody sigh, life is hard, I'm always tempted to ask, compared to what, from Sydney Harris. And look, that's not saying that life isn't hard and that life can't be hard. It certainly can be. But yeah, just a little bit of compared to the alternative. Yeah, it's sort of like a bit of perspective. Our life is our life, and sometimes we just need to crack on, particularly in year 12. We're certainly not going to enjoy every moment of it or find every moment easy. But at some point, we just got to turn up and get the work done. So, as we head into Area of Study 2, hopefully that's the attitude of most of you. Today we are looking at key principles. So again, that word key principles, not the principles of justice, the key principles in the Victorian civil justice system, including burden of proof and standard of proof. So just two, burden of proof and standard of proof, and we'll basically look a little bit at how they differ from the criminal versions. A key skill is really just define and use key legal terminology. So effectively, at the end, what are the key principles that exist in the civil justice system? We'll crack straight in. The burden of proof, so not similar, pretty much exactly the same as a criminal dispute. Two key parties in a civil matter. In a civil dispute, the two parties are the plaintiff and the defendant, rather than the prosecution and the accused or defence. So the plaintiff and the defendant. You might be able to better remember that by plaintiff and prosecution both starting with P. So plaintiff, prosecution are the parties that bring the case. And whoever is responsible for proving the case, we know, has the burden of proof. It always rests on the party who brings the case. Again, the party that's bringing the case is the party that is making the allegation. It is only fair from a natural justice standpoint. Even though no principles of justice apply to this dot point, it is worthwhile thinking about it through that lens of fairness. It is only fair if you are making an allegation against someone that you are then responsible for proving that allegation. You think about, in the home, say siblings, things like that. If you're going to go to mum and dad or guardians and say, hey, my brother did this, it's only reasonable for them to say, hey, basically, before I action that, before I do anything about it with your brother, can you prove it? What are you going to show me so that I can actually, in a way, believe you? So if you bring an action, if you take something to court, if you claim that someone has harmed you, you are therefore the person responsible for proving that. So you bear the burden of proof. So the plaintiff bears the burden of proof. This protects the presumption of innocence, similar to, presumption of innocence is a criminal terminology, but it still is the same in a sense in a civil action. You are considered not liable until the plaintiff is able to prove that you are liable. That also, as usual, means the defendant has, in a way, less of an obligation to defend themselves than the plaintiff has to prove. However, as we'll see in a civil matter, there is a lower standard of proof. So we know the standard of proof is the level to which it has to be proved. In a civil trial, that is on the balance of probabilities. Criminal matter, beyond reasonable doubt. The prosecution has to prove beyond reasonable doubt that you committed a crime, which means you have your right to silence. You don't necessarily need to defend yourself. It's all about the prosecution meeting that high evidentiary burden. That high evidentiary standard. The standard in a civil case on the balance of probabilities is lower. I've actually got that listed below because that's how important that point is. It is lower than criminal. Okay, so in a way, if we think about the old-fashioned scales of justice, a civil case is more or less you stacking enough evidence, quality of evidence, not just quantity of evidence, you stacking enough evidence on your side to tip the scales in your favour. So effectively, your story, your allegation, if you're the plaintiff, is more likely to have occurred. Your version of events is more likely to have occurred than the opposing parties and the defences, or vice versa. The defence is trying to present enough evidence to support their case, to show the court that what they're saying in their defence, their version of events, is more likely than yours as a plaintiff. So the balance of probabilities, which is more likely? So effectively, you're on much more even footing in a civil case around your need then to actively engage in the case, bring witnesses, evidence, defence, etc., as opposed to very much the strong right of silence that an accused has in a criminal matter. Define and use key legal terminology. So, maybe a question, define one key principle of the civil justice system. You could get something as similar as that. Burden of proof, who has to prove a case? It's always on the plaintiff. Could be a question as straightforward as that. These are very much like you might get case studies where it's like identify who holds the burden of proof. And it's a really common one that they might try and trick you with. They might try and give you a case that in a scenario in Section B that includes both a criminal and a civil case, and they'll try and say, identify who holds the burden of proof in the civil case. And you've got to figure out which part of it is the civil case and then who would be the plaintiff. But yeah, pretty straightforward. We always have, this is actually key, it should be 3-2 there, but synthesize and apply. This is just a classic. Go find some, say, a news website, try and find a civil case. You might Google civil case Victoria. Really good one at the moment is if you search AFL concussion class action. There's a few articles floating around at the moment about this. A bunch of past players are suing the AFL around how they've dealt with concussion. There's also an AFL racism civil case that you might be able to find. Have a look at those and consider, okay, who is making the allegation, therefore who has the burden of proof, so who are the plaintiffs, and then thinking about then how they might be trying to prove it on the balance of probabilities compared to how the AFL might be defending it. Just a good way of applying your knowledge. Hopefully, if someone says to you, hey, notice, they might have noticed in the media a previous criminal case that's now in civil courts. Good example is the Bruce Lehrmann defamation matter in the ACT. That's a civil matter that's sitting with the judge now for judgment later this year. That was also a criminal case that was run last year. Someone might ask you about why it's, been a criminal case and now it's a civil case. They might ask you about what the difference is between those two things. And you should be able to tell them, hey, yeah, well, one of the key differences is that the burden of proof is lower in the civil matter, and explain how, that concept differs across the two types of cases. Ben Roberts-Smith is another good one. His civil matter, he was found... he tried to sue for defamation, and the newspapers were found not liable, and the judge actually said, based on the evidence presented, it was more likely than not on the balance of probabilities that Ben Roberts-Smith was a war criminal, but he's then never been convicted or faced criminal charges on that front, which suggests that perhaps on the balance of probabilities, it's more likely than not that he's a war criminal, but a prosecution agency might not believe that they can meet beyond reasonable doubt in a criminal case. So that's a good, again, applicable example of how those differ, these key principles differ from criminal matters to civil matters. As always, any feedback below, but yeah, hopefully a nice quick one for you to start this area of study.